Just as we discussed in the sections on race, color, and national origin, customer or coworker preferences is not a legitimate protected reason to treat qualified employees differently based on gender. So if we've got candidates who are qualified for the job, just because the customer doesn't like them is not our problem. The bottom line is you are obligated to provide work opportunities for everybody, and your customers can choose whether or not they want to come work for you, come and do business with you based on the fact that you've got women or minorities or different ethnic groups in your organization. And the same thing holds, as I said, for gender. Hooters is a really weird situation. It's a very big challenge. Fundamentally, Hooters considers itself a family restaurant. At the same time, it also says it entertains, and it uses its waitresses as entertainers. And in essence, the way Hooters gets around what they do by simply litigating and settling every single case that comes up where they get told that they are treating male applicants different than they treat their female applicants. And in fact, males who want to apply for jobs there, get turned down, and then they usually go to court, and then that usually gets settled in some way. And as long as Hooters wants to do that and continue to do that, they can continue to pay. There may come a time when there's enough action against them to say that this is just not working because fundamentally they're really not a family restaurant. We all know what Hooters means. We all know what the expectation is. That Hooters are really another word for women's breasts, and more than a mouthful is really not also talking about the food. So say what we will, and they can argue all they want all day long. They would have to be an adult entertainment an adult entertainment organization in order to absolutely get away with it in the court of law. They haven't really been challenged that much in a court of law. They have certainly been able to justify on a case-by-case basis that they are really a family restaurant because they have crayons available for kids. Well, okay. We all know. I don't know. In my mind, they're not a family restaurant. I don't see that as a family restaurant. I'm not saying I have any problem with Hooters necessarily in and of itself, but don't tell me it's a family restaurant because it's really not. I wouldn't bring my kids there. In 1991, an amendment to Title VII looked at the application of this outside of the United States. Title VII applies to U.S. citizens employed by American-owned or controlled businesses outside the United States, unless the local law forbids it otherwise. And for example, you can look at Saudi Arabia. Local law prohibits women from working. So you might be able to get away with having a woman do some work in American-owned business if they're not dealing with customers or clients, in which case they can do the work behind the scenes. They're American citizens. They should be fine. But where they might be dealing with male clientele, if you're doing business in Saudi Arabia, you'd have to follow Saudi Arabian rules. Employers may not refuse to hire those of a certain gender because of logistical issues. For example, a female sports reporter going into a male athlete's locker room, or vice versa, a male reporter going into a female locker room. We can't do that. Female firefighters sleeping in a fire station. You need to provide, a place for them, period. Lack of bathrooms at a construction site. You have to provide bathrooms for people. So you can't say, well, it's just too much of a burden. We're not going to, not do this. Unless, of course, it is too high of a financial burden. I mean, and really, it's not a burden to figure out how to separate sleeping quarters. It's not a burden to, make sure that you've got bathrooms on a construction site that women can use, et cetera, et cetera. So it is important, to be clear what is considered to be an unreasonable burden. And that standard's fairly high because most companies can afford to put in an outhouse or to set up extra cots and borders, and there's lots of things that can be done. But these are great examples of situations where the logistical issues did not interfere with people's abilities to still hire women or, to do jobs, even if they seemed like a logistical problem. You work through the logistical problem. In terms of breastfeeding or expressing milk at work, the Obamacare, the American Care Act requires 50 plus full-time employees, any organization with 50 plus full-time employees, to provide reasonable private non-restroom facilities for women to be able to breastfeed and or pump milk at work. Now, most people don't have their children at work with them. Although if there's in-house daycare, of course, then there are circumstances for that. But um, uh, it's really what it comes down to mostly is if you're a breastfeeding mom that you're going to go back to work, you're going to be expressing milk. And you need to have a private facility to be able to do that doesn't involve the restroom. Because no way you want to have pumping breast milk, which is supposed to be clean and nurturing, in a bathroom where there's all sorts of germs and stuff in there. And speaking as someone who was a breastfeeding mom, yeah, that's not okay. There are some state laws that go further than that, and you need to know state by state which states require you to have lactation rooms and which do not. But by and large, the Affordable Care Act requires us to make sure that, if you have at least 50 employees in your company, their full-time equivalents, that you've got a private, non-restroom related facility for them to be able to do that work. In terms of equal pay and comparable worth, we're going to start with the Equal Pay Act, and so you understand that. And remember, there should be equal pay between men and women if they're doing similar work or under similar conditions. So here's what the statute says. No employer shall discriminate between employees on the basis of sex by paying wages to employees at a rate less than the rate at which he pays wages to employees of the opposite sex for equal work on jobs, the performance of which requires equal skill, effort, responsibility, and which are performed under similar working conditions, except where such pay is made pursuant to seniority, a merit system, and a system which measures earnings by quantity or quality of production, or differential pay based on any other factor other than sex. So the Equal Pay Act overlaps with Title VII's prohibitions on discrimination based on the basis of gender, and it specifically addresses pay. The Equal Pay Act is about the practical content of the job, not necessarily the title or the description, but it has been really effective and ineffective at closing that wage gap. So the challenge, of course, is there comparable worth? If there's comparable worth in the jobs, if you're doing a job analysis, and in your job analysis you find that even if it's a different title, but you basically requires the same skill, the same effort, the same responsibility, et cetera, it should be paid the same. But sadly, we still know that personal bias enters into it, that there are jobs that women do, by and large, that gets a lower rating than jobs that men do. And there's plenty of evidence out there on that. Recent state laws are putting the burden on the employer to justify those differences. And California, of course, is always at the cutting edge or the leading edge of many of these sorts of things. So the issue of comparable worth, how do we legislate comparable worth other than getting at the job evaluation process, which, as much as we try to make that objective, it is still fairly subjective. We have to determine what skill or effort or responsibilities are required in that. It requires a subjective judgment of it. So it's very frustrating. And so issues of pay are difficult to legislate and to litigate, rather. It's challenging. So Title VII's Bennett Amendment basically was passed so that the exceptions permitted by the Equal Pay Act would also be recognizable by Title VII, right? So, and it says that, unequal pay action need not be substantially. Jobs compared in a Title VII unequal pay action don't have to be substantially equal. They have to be relatively similar, within a certain range, I would assume, that they come up with. The Equal Pay Act has a longer statute of limitations. It's important to recognize that. The Lilly Ledbetter Fair Pay Act extended the statute of limitations for each discriminatory paycheck. So even if the initial discrimination started 10 years ago, the statute of limitations is extended for every discriminatory paycheck that the individual gets. So basically, if you were discriminated against 20 years ago, there's this compounding effect, right? You were already at a lower pay right then, and then it compounds over 20 years. And so as long as your pay is never fixed to be adjusted to be appropriate to make it comparable, you will always be at a lesser rate. Because of course, by the time people figure out that they're being paid inappropriately, sometimes that statute of limitation is gone. Um, Title VII, action for pay discrimination based on gender. It's comparable worth, and it's, well, how do we determine what is the comparable worth between two separate jobs? Jobs held mostly by women are compared with comparable jobs held mostly by men. And the goal is that we need to see comparable pay, right, for those jobs across the board. And pay is compared to determine if there is gender discrimination. And so that's the goal, right? In your organization, looking at jobs that are predominantly women, looking at jobs that are predominantly men, and seeing what the comparisons are to make sure that we are paying them fairly, reasonably, in the same range. Title VII does permit gender to be a bona fide occupational qualification under very limited circumstances. For example, theater roles, or for example, women prison guards in a male-only prison and vice versa. Uh, Very limited circumstances. They're very hostile. The EEOC is very hostile to any notion that we're allowed to legalize discrimination, which is why it's not even relevant with respect to race and color. It's just not even relevant. And under limited circumstances is relevant for ethnic origin. But the standard that we use is, men can only be sperm donors, or women can only be wet nurses. And so it would have to be that extreme of a circumstance, right, in order for us to determine that, nope, women cannot be in this job, only men, and vice versa. Men can only be in the women can only be in this job, not men, vice versa. And the EEOC versus Women's Workout World, they argued that they should not allow men to be in the workout place as managers or assistant managers because of privacy related issues. That if a woman wants to go and work out there and they wanted to dress in a particular way, or if they wanted to be in the locker room, to have men around would be uncomfortable or would be a violation of privacy reasons. And the courts ruled that that was just not compelling enough. At least certainly it's not that privacy wasn't compelling. It's that the argument they made wasn't compelling enough to hit the threshold that mattered. It's really probably a more appropriate way of putting that. And the court, they said that the purpose of the operation is to provide individualized fitness and exercise to club members. The employer would have to prove that it could not achieve its business purpose without engaging in single gender hiring. The assertion that the alternatives were not feasible because of the views of its clientele and the difficulties of accommodating men in the health club were not strong enough to prove no alternatives were feasible. That doesn't mean you couldn't make the case, but your argument would have to be a lot stronger. You would have to show some definite, you would have some hard data to show that this would definitely be a problem. So something to think about. A BFOQ has been found by courts in limited circumstances, but other than that, we try very hard to not say that sex or gender is a BFOQ for any particular job. With the Pregnancy Discrimination Act, that prohibits discrimination based on pregnancy, childbirth, or any related medical conditions. People have to be working for the company for a certain period of time before that kicks in. You have to have a certain number of employees, obviously, also for that to kick in. But this was enacted following the Supreme Court's conclusion that discrimination on the basis of pregnancy was not considered gender discrimination under Title VII. God knows why. So the Pregnancy Discrimination Act was created to amend the initial Title VII so that pregnancy would be considered part of gender discrimination. Fundamentally, while the issues of transgender men giving birth to babies was not necessarily relevant at this point in time, certainly wasn't. It wasn't considered an issue at this point in time, or certainly didn't come up as relevant at this point in time in the courts. But women can only get pregnant, and so why would you not consider that to be a form of gender discrimination if you were treating people differently because they could have babies? So 2 years after the Supreme Court's conclusion, They came up with the Pregnancy Discrimination Act, amending Title VII to include pregnancy. So it is now there, rock solid. 182% increase in the filing of pregnancy discrimination charges over the last 10 years. Why? I have no idea. I really wish I could understand this. I don't understand why we're having increased litigation regarding these issues. It's very frustrating to hear, is that people are having babies and yet they're being treated differentially, as if their pregnancy is irrelevant, and that they should not have jobs because of that. I don't get it. Okay, the case Young versus UPS 2015, it extended the use of the term reasonable accommodation concept to assist pregnant employees if a company's policies included other similar temporary disabilities. So if you have a temporary disability under your policies, reasonable accommodation was considered appropriate. Could we reasonably accommodate somebody who needed changes in their working hours or different desk or some other accommodations to help them to make work more comfortable? There are fetal protection policies out there that an employer institutes to protect the fetus or the reproductive capacity of employees, um, to that limits or prohibits employees from performing certain jobs or working in certain areas. And the UAW versus Johnson Controls case basically came about, um, that you cannot limit access to a job, that as long as people are aware of access to these positions, that there are risks to the fertility, that they're entitled to be able to, they should be entitled to do those jobs. Um, so what happened with Johnson Controls is a group of employees challenged the employer's policy barring all women except those who had medically documented infertility, whether they were in menopause already or they had a hysterectomy or they had not been able to conceive. So that they were limited from jobs that exposed them to lead. Included in that group was a male who wished to transfer out of the facility in order to bring up his sperm count because the lead was decreasing his sperm count. Scientific evidence showed that the lead exposure had an adverse impact on the reproductive capacity of both males and females, yet they only limited women from having access to those jobs. So the courts basically found that that was illegal discrimination, that if men and women both could be negatively impacted, then of course that would be a form of discrimination. And what it really sort of comes down to too is if a woman can make her own decision, if she knows by exposing herself to this that she could potentially decrease her fertility, and she signs an agreement saying that she goes into this knowingly and willingly, then that's what matters the most. So they're taking away her autonomy and the abilities to sometimes do jobs that have higher pay, right? So our final management tips. Overall, we want to send the message out in word and deed that gender bias is not going to be tolerated in the organization. We want to have a backup policy, back up the policy with appropriate enforcement. We want to make sure that not only do we have it in words, but we have it in actions, that we will punish and follow through on punishments for anybody who is found guilty of gender bias or gender discrimination. We want to take the complaints seriously, promptly, thoroughly, etc. Make sure that any punishment fits the crime. So we want to make sure we don't have slaps on the hand, but we also want to make sure we don't have extreme punishments either, if things can be mitigated and conciliated between the parties in the organization. We want to conduct periodic training to remind employees about anti-bias policies. We want to make sure that we're conducting periodic audits and reviewing workplace policies to make sure there's no adverse impact. So this is part of what you have to do at HR by keeping track of the flow statistics, the stock statistics, and the concentration statistics. We're checking regularly for adverse impact to make sure that one group or another is not experiencing adverse impact based on gender. Pay audits, pay gap audits are going to be a really important part of this too, making sure that we don't have differential problems between what we pay men and what we pay women. and we want to make sure that we are taking actions to address gender issues that need not make the workplace stilted or formal, right? We can address gender issues without making everybody feel like nobody gets to talk to each other anymore for fear of discrimination. I mean, it's, the extreme response to these sorts of things. It's not an all or nothing thing. We can actually find a halfway happy median in terms of the way that we treat each other in the workplace. The bottom line is the EEOC does not tolerate sex-based discrimination, period. Organizations may still engage in it, but the EEOC has very little patience for it, if you will.